You've probably seen this online, right? Someone gets angry and threatens to sue an anonymous critic, vowing to subpoena them and reveal their real identity. It's a classic internet threat, but it begs a huge question. When you're speaking your mind anonymously, how much does the law actually have your back? Can someone really just use the courts to pull off your mask? Well, let's get into it. So, check this out. This quote is from an online creator who felt he was being harassed and promised he was coming after his anonymous critics with subpoenas. His whole argument was, hey, this is my constitutional right, and if you're fighting it, you must have something to hide. But this idea the First Amendment just gets thrown out the window for speech someone finds offensive or false, that's exactly what we're going to put to the test, right? So let's cut through all the online drama and the threats. What's the actual legal reality here? How do courts handle this tug of war between someone wanting to unmask a critic and that critic's right to speak anonymously? Well, the answer is way more complicated and honestly, way more protective of speech than you might think. Okay, so before we get into the nitty-gritty of today's legal tests, we have to start with the foundation because in the United States, speaking your mind anonymously isn't some new thing cooked up for the internet. Nope. It's a principle that's been protected by courts for a very, very long time as a core part of free expression. Now, here's what's so interesting. If you go and read the First Amendment, you're not going to find the word anonymity anywhere. But the Supreme Court has said time and time again that the freedom of speech itself includes the right to decide to stay anonymous. Why? Because they recognize that without that protection, people would just be too scared of getting punished or harassed to speak up about really important, often controversial issues. And this isn't some new idea. Just look at this timeline. We're talking way back in 1958 with NAACP v. Alabama. The court knew that forcing an organization to reveal its members would create a chilling effect on free speech. Then you have Talley protecting anonymous pamphlets and McIntyre protecting anonymous campaign flyers. These cases built this incredibly strong legal shield for anonymous speakers, brick by brick. But, and this is a really big but, that shield is not made of vibranium. It is not absolute. Your right to be anonymous is at its strongest when you're talking about your opinions or criticizing powerful people. It is not a free pass to say literally anything you want and expect zero consequences. There are some very clear legal lines you can cross. So this is the key distinction you have to get. Your opinions, your political arguments, your criticism, even just being over the top and insulting, that stuff is generally protected. But once your speech crosses over into these legally defined categories, we're talking defamation, real threats of violence, or a pattern of behavior that counts as illegal harassment, that's when the First Amendment protection starts to peel away and the door to getting unmasked creaks open. Now, the weapon of choice for trying to unmask a critic is usually a defamation lawsuit, specifically libel, since we're talking about written words online. But just look at this definition. It's not as simple as saying something mean, or even something that isn't true. To win, a person has to prove all four of these things, that it was false, that it was defamatory, that it wasn't privileged, and that it actually caused real measurable harm. That is a seriously high bar to clear. So with all that in mind, how does a judge actually decide whether to force, say, Google or X to give up your identity? Well, California has one of the clearest and most copied legal frameworks for this whole thing. And it's not a simple request form. It's more like a legal gauntlet that the person suing you has to survive. This is it, the three-step test from a huge case called Krinsky v. Doe 6. Let's break it down real quick. First, they have to try and let you know they're coming for your identity, so you get a chance to fight it. Second, and this is the big one, they can't just say you did something wrong. They have to show the judge actual evidence, a real prima facie case that your words were legally out of bounds. And only if they pass that step does the court move on to the final balancing act. And if you think I'm exaggerating how hard that second step is, just look at this quote from a real case. A company called Hydraulics sued an anonymous emailer, and the court just shut them down completely. They said flat out that the company failed to make a prima facie showing. They didn't bring the receipts, basically. They couldn't prove the speech was actually defamatory. The court in that case actually did this fascinating breakdown. The emailer saying he didn't like what he considers bad business practices. The court said, yep, that's a textbook protected opinion. But the claim that two companies were co-owned by the same people, that's different. That's a statement of fact you can prove is either true or false. But here's the kicker. Even though the ownership claim was false, the court said it wasn't. Hydraulics couldn't prove that this one false statement actually hurt its business or reputation. And this is such a critical point, you guys. Just catching someone in a lie or mistake online is almost never enough on its own to justify unmasking them. The person suing has to clear that much higher hurdle of proving actual harm. So the legal test is already really tough. But wait, there's more. On top of that, there's a whole mess of procedural and legal roadblocks that make trying to unmask someone even harder, more expensive, and a lot more time-consuming than people think. These are some of the biggest showstoppers right here. You've got California's super powerful anti-SLAPP law, a federal law called the Stored Communications Act, the crazy tight deadlines you see in restraining order cases, and special rules for getting personal records. Any one of these can be a brick wall for an unmasking attempt. Let's talk about the big one for a second, anti-SLAPP. This law is specifically designed to shut down bogus lawsuits that are only being filed to shut people up. The minute a defendant files an anti-SLAPP motion, the law basically hits the emergency brake on the whole case. All discovery, including any subpoenas, is frozen solid until a judge can look at the lawsuit and decide if it has any real merit or if it's just trying to silence a critic. And this thing has been on the books since 1992. It was created because lawmakers saw what they called a disturbing increase in lawsuits brought primarily to chill the valid exercise of constitutional rights. It's an incredibly powerful tool that can just completely flip the script on someone trying to use the courts to find out who's criticizing them. Then you've got this federal law, the Stored Communications Act. This is another huge hurdle. Even if someone manages to get a platform, this law generally forbids the company from handing over the actual content of private messages like your DMs. They might be able to get basic info like your name or IP address, but the private conversations themselves, those are heavily protected. And what about those civil harassment cases? The ones for restraining orders? Well, the timeline is fast. A hearing is usually set within 21 days. Is that enough time to file a lawsuit, serve a subpoena on a massive tech company, give the anonymous user time to see it and object, and have a full-blown court battle over it? Almost no way. The system is built for speed, which totally works against this kind of complex legal fight. Okay, so let's zoom out and pull all these pieces together. We've talked about the constitutional right to be anonymous, the really tough legal test to unmask someone, and all these practical roadblocks. So what's the big picture here? What does it all mean? This table really lays it all out for you. You've got multiple layers of protection, from the very top at the Supreme Court all the way down to state and federal laws. From the big ideas in cases like McIntyre to the very practical power of the anti-SLAPP statute. The whole system is built to stop people from saying, first, tell me who you are, and then maybe I'll figure out if I have a case. That tactic just doesn't fly, and that right there is the heart of it. The legal system sets this incredibly high bar for a reason. It is designed to make sure the legal process can't just be used as a sword to shut down critics. The whole point is to make sure lawsuits are used as a shield, to protect people from real, actual, provable harm, not just to silence voices you don't like. But that leaves us with this one giant, lingering question for our time. We've seen just how strong the shield protecting anonymous speech really is. But in today's world of online mobs, targeted harassment, and misinformation that spreads like wildfire, have we gone too far? Is that shield now so strong that it's become almost impossible to hold people accountable for the very real harm they can cause from behind a keyboard? That tension right there is at the very center of the free speech debate today.